shows that we are at 3:30. So we are going to go ahead and kick this committee off. All right, so I am going to start off by asking the committee what is the will of the committee for the minutes for February 2nd, 4th, 9th, 11th, and 16th.
Mr. Chairman, I move that we approve the minutes of those stated meetings.
Okay, and then I have a motion to approve the minutes from Representative Berquist with a second from Representative Dodson. All those in favor, please signify by raising your right hand. All those opposed? The ayes have it. Minutes are approved. For the first order of business, actually the second order of business today, we are going to have a hearing on House Bill 2326. And for an overview of House Bill 2326, the chair will recognize Revisor Heim.
Mr. Chairman, members of the committee, this bill amends a statute dealing with the election of precinct committeemen and committeewomen and the appointment of them, those offices or officials when there is a vacancy. The amendment is on page 2 of the bill, a new subsection C. It provides that all precinct committeemen and committeewomen shall report to the county election officer their address, phone number, and email address if available. Phone numbers and email addresses shall not be considered a public record under the Open Records Act, but shall be disclosed to the appropriate chairperson of the county central committee and the state party chairperson. If you've got questions, I'll try and answer them, but that's about as much as I can say about the bill.
All right, committee, are there any questions for the revisor at this time? Representative Parker.
Thank you, Mr. Chair. Mike, do you know, is there a precedent, and there might be, I just don't know of this, for being able to just carve things out of the Open Records Act? Is that done anywhere else in statute where we can just sort of in statute say this is an exemption?
There are other examples. One way to do this would be to go in and amend the Open Records Act itself, but I didn't think it was necessary in this case.
No, that's fine. If it's precedent, that makes sense to me. It seems better, simple like this. Thank you, Mr. Chair.
Any other further questions for the revisor? Seeing none, thank you, Revisor Heim, for the overview. So we're going to go ahead and open the proponents section of House Bill 2326. For the first proponent, we have Representative Tatum Lehon. I would say welcome to committee, but you're here every day anyway.
I'm here every day, almost every day. Thank you, Chairman Carpenter and committee, for hearing my bill today, HB 2326. You have my testimony in front of you. What this bill simply does is clean up and provide some clarification for all precinct committee persons to submit their phone number and email address with their already required physical address. This is important to me because I've experienced it very recently. I was elected in November and then again in December by a vacancy committee. And now with Senator Bud Estes' seat, we are struggling to notify all of the committee people of this vacancy. And so this would really just make sure that every voice is heard. And I would request that, with the permission of the committee, that I would present a friendly amendment that will bring a few word changes to include appointees and having the information available to district committee leadership as well. With that, I will stand for questions at the appropriate time.
Thank you, Representative. We're going to hold questions until we hear from all the proponents. So the chair now recognizes Mike Kuckelman, Chairman of the Kansas Republican Party.
Good afternoon, Chairman Carpenter. My name is Michael Kuckelman. I'm Chairman of the Kansas Republican Party, and I am a proponent of House Bill 2326 because it increases civic engagement and makes communication with precinct committee people or members more efficient. I would make 3 comments on this legislation. The first, I'm guessing that it's not likely it's controversial, and I would expect that there be full bipartisan support of this legislation, because it simply makes it much more efficient to communicate and to have the engagement of precinct committee people. But second, I think it's important to point out this bill balances the expectation of privacy of these precinct committee people with the need for county chairs and state chairs to access contact details of precinct committee members with the chair or the chair of the state party. And the last comment I would make is the need for this information. It's necessary because it makes it more efficient and timely to communicate with these precinct committee members. We've had situations in the past where chairs have had trouble contacting some of their own precinct committee people. Sometimes these conventions to replace or to fill a vacancy, they're under some time constraints, and it's just simply a lot more efficient to be able to do it with having more contact details such as emails and telephone numbers in order to do that. So with that, I will just again emphasize that we do support, we are a proponent of this legislation.
Thank you, Mr. Chairman, for your testimony. The chair now recognizes Laura Tawater, Kansas GOP, 1st Congressional District Committeewoman.
Mute here. Mr. Chairman and members of the committee, thank you for allowing me the opportunity to testify in support of House Bill 2326. Thank you for hearing this bill today. I'm honored to be able to visit with you about it. As the chairwoman for the Kansas Republican Party's 1st Congressional District, I work closely with the 63 county party central committees in what we call the Big First. And so I have regular contact with our members, provide them with information, meeting notices, and assist in these special elections, which we seem to have a lot of. I did speak more in detail in my written testimony that I submitted yesterday. But just kind of for instance, and Tatum spoke a little bit about this, when we assist with these county and state special elections, which is often we lack the information we need to contact our precinct committee people. So even when we send out written notices, oftentimes we make phone calls, follow-up phone calls. We talk to our precinct committee people. We're available for questions if they've not been part of a convention before. Remind them they need to bring their ID, but that doesn't happen when we don't have phone numbers, especially, but emails sometimes. So special elections kind of become chaotic when we don't have all of our precinct people who are voting in that special election when we can't make contact with them. I'm working on a directory for our Big First, and so we lack a lot of information there. We've got addresses, but no phone numbers, or, you know, we've got one piece of information here and there, contact information here and there. As it is now, candidates that are filing to run in their precinct aren't required to report that information, certain contact information on their filing forms. And so county clerks aren't required then to disclose that information. So there's just been a huge disconnect between the party and our precinct people, which is really our biggest base. And we really want to make sure that we are reaching out to them. So again, this is a bipartisan bill. It would benefit both parties. And with HB 2326, we would be able to collect that specific information from county clerks with that requirement in place. And it would just really help us streamline this preparation for special elections, conventions, trainings, that kind of thing. And so very simply, we just want to be able to reach out to our precinct committee people, fulfill our organizational duties, and help them become involved in the party. And so with that, I will close. Thank you, Mr. Chairman, committee members, for your time today, and I will stand for questions when appropriate.
Thank you for your testimony. Committee, I will point you to several written opponents at this time. Committee, are there any questions for the proponents? Chair recognizes Representative Miller.
Thank you, Mr. Chairman. This sounds like a good bill, but in the course of that last testimony, a question came to mind, and I apologize, I don't have the bill in front of me, but reading the title of the bill, it would appear that the only people who would get the phone number and email address would be the county and state party chairpersons. But as Ms. Tallwater was talking, I thought I heard her talk about distributing that then to people throughout the district, creating a directory, which implied to me that then it would be widely disseminated. Did I misunderstand that?
Ms. Tarwater?
Yep. So creating a contact list for our the district committee leadership so that we can reach out to them, not given out within the district.
May I follow up? So if in the case of one of these special elections, would candidates not have access to the phone numbers of the people that would be voting?
They can call the county clerks within that district and retrieve it that way.
So it would be part of the public record? I thought that was the purpose of this bill, so it wouldn't be part of the public record. Only the clerk would have it. Am I missing the point, Mr. Chairman?
I believe that you're trying to make the point that
No, I'm trying to understand are the phone numbers and email addresses going to be public information once we pass this bill?
based on line 8 and 9 of page 2, no, that is not correct. Because it is, these items shall not be considered a public record under the Open Records Act.
So as a candidate, I wouldn't be able to access the voters via that information?
Candidates are not listed as people who have access to that information.
Now I have a problem with the bill. Thank you.
Thank you. Committee, are there further questions for the proponents? If yes, you may address the representative's comments.
Thank you, Mr. Chair. Representative Miller, actually, prior to coming in here today, I just spoke with a county clerk back in my district, and she also mentioned the piece about the Open Records Act, and I would defer to the will of the committee. I've not taken a hard line one way or the other in terms of making it a part of the Open Records Act or keeping them closed. I'll be interested to know what Mr. Hypo, what his testimony is, but she was under the impression that it would be easier for the county clerks to not carve that out, and for those things to still be, for those pieces of information, the email address and phone number, to be also considered as part of the Opens Record Act, which would allow candidates access to that information.
Representative Miller.
May I ask the sponsor a question?
Yes.
Was it your intent, is it your intent? I've been through the same process you have, and I can't imagine that process lacking the contact information for the very people I would be appealing to have their votes. Was it your intention to prevent the dissemination of phone numbers and email addresses to the delegates that would be voting in a special election?
No, that was not my intent. My intent is to make it as transparent as possible for the information for these precinct people to be contacted. What we found, for instance, in both my special elections, is that a lot of these smaller county committees don't have the funds available to send out mailers, and all they have is an address available. And so it just causes a lot of headache to try to be able to access these people.
But the way I read the bill, that information would be limited to the party chairperson, not how would the candidates get the information if only the chairperson can have it?
I would be open to you bringing a friendly amendment to that and changing that if you think that that's.
No, I don't want to mess with your bill. I want it to be the bill you want. And that's why I'm asking questions. I'm not sure it is what you want. And I may be wrong about that. Thank you, Mr. Chairman.
Chair recognizes Representative Proctor.
Thank you, Mr. Chair. So question for I guess for Representative Lehan, but
Does anything in this bill or in the amendment that you intend to bring when we work the bill prevent the county chairs or the district chairs, if you do amend it, from providing contact information to candidates? Is there anything that would prevent that?
That's not the intent, is for the prevention of information to go to those candidates. When I received this back, I thought, oh, we might need to bring an amendment to that. And again, completely open to the will of the committee in doing so.
Yeah, but I just, to the previous representative's point, the candidate, even under this bill, the candidates could go to their county chairs and they could get that information, correct?
Yes, sir. They absolutely could.
Chair recognizes Representative Collins. Hold on, Representative, we cannot hear you.
About now, can you hear me now?
Hold up, go ahead.
All right, thank you, Mr. Chair. I was just wondering about the, if anyone could answer about the open records part of my county chair back home has pretty much a list already of names and email addresses and phone numbers. Just, you know, sometimes we might be having some kind of get together or something, and they might share that information with the person sending out the invitations. And I was just wondering if that would prohibit the chairperson from giving out that information to the person who's delegated to do that in that type of situation.
Do any of the proponents wish to address that comment or question? Chair recognizes Representative Lehan.
So the intent of the bill is to make this as easy as possible for people to be able to get the information of the precinct people. And as Representative Proctor has indicated, if a candidate wants to be able to get the information of those precinct people, he or she would be able to go to that county clerk or that presumably the party chair in that county and get that information. Does that answer your question, Representative Collins?
Not really. I'm just thinking within the structure of a county committee. Like I said, I think the county chair where I live has that information already as far as me as a committee person. And I was just wondering, I'm just concerned that this will end up being an open records violation if that person like gives a mailing list or what have you to other members of the county committee.
All right, so are there any final questions for the proponents? I'm seeing none at this time. So we're going to go ahead and close the proponent section of House Bill 2326. We're going to open up the opponent section. I have none listed. Does anybody wish to testify as an opponent? Seeing none, that section is now closed. I'm going to open up the neutral section. We have two written neutral only testimony from the Secretary of State's office and Loud Light Civic Action Group. If you peruse those at your convenience. Then, are there any other neutrals that wish to testify? Seeing none, the neutral section is closed.
Mr. Chairman.
Yep.
Just a comment, and you can obviously amend the bill in any way you see fit. The Open Records Act has a provision in it, the 49th exception to openness says all individual email addresses, cell phone numbers, and other contact information which has been given to the public agency for purposes of the public agency notification or communication, and so on, are basically can be restricted. So I think maybe that was some of the philosophy of restricting this, but there's some issues that have been brought up in the course of the hearing that maybe in this particular case, you need some more exceptions to the restriction.
Thank you, Revisor Heim. Committee, are there any further comments? Representative Proctor.
Thank you, Mr. Chairman. I'd like to ask the revisor a question if I could.
Proceed.
Mr. Heim, is in the statute, do committee people have to be notified by mail for special committee meetings? And would this bill in any way change that requirement?
If you need some time, Revisor Heim, we can come back to you.
To me, I don't think it addresses whether or not I assume you have to mail it if all you've got is their address, but I'll look to double check, but I don't think it covers it.
All right, thank you, Revisor. Committee, are there any other follow-up? Representative Topliker.
Thank you, Mr. Chairman. The issue of a public record to me is a question of a public record is something that isn't required to be given out, or it's not something that a government employee would be required to let that record be known to the public. But Mr. Chairman, my question is there anything that prevents someone that has that information under this proposed language? Is there anything that would prohibit a person that has that information to give it out to someone else? I mean, to me, this bill doesn't say that another person that has that information cannot give it out. It doesn't say that. It doesn't prohibit someone that has the information to give it out. Could you, Mr. Revisor, could you correct me if I'm wrong on that?
Mr. Chairman, members of the committee, the Open Records Act, the presumption is that all records are open unless specifically restricted from, or if there's some federal or state law or an exception in the Open Records Act itself or in some other provision of state law. So you start from the proposition that all public records are open and you go from there. So if you want to restrict this information, you need to specify how you want it restricted. If you don't care, then just delete that from the bill.
All right. Thank you. Committee, are there any final quick comments? Seeing none. Representative Miller.
I do have the bill in front of me now, and the way I read it, the clerk can't disclose this information to anyone but the designated chair people here, but the chair people can disclose it to whoever they choose, which might create a problem if there was a race going on for to fill a vacancy and the chairperson had a favorite and only provided the list to their preferred candidate. I have a real problem with that. Thank you.
Representative Berquist.
Yes. I was in a similar situation to the representative who brought the bill, and it was very difficult to scour up a few precinct committee members to know who I was asking to consider to vote for me in a very short time. I had just a week and a half or so to get everybody notified, and I was fortunate to have help. But if I hadn't had somebody that was willing to give out, to be forthcoming with the information, it would have been very difficult for me to know who I was asking, and therefore I wouldn't probably be here.
All right, thank you. We're going to go ahead and move on. So committee, turn your focus to House Bill 2355. For an overview of 2355, the chair recognizes Riser Heim.
Mr. Chairman, members of the committee, this is a bill that was brought to the committee by the Secretary of State's office, and it's a clarification and a cleanup kind of a bill. The first section amends the general bond law, and the amendment, it basically extends the time frame for the election to be held under the general bond law from 45 to 60 days, but not sooner than 45 days, with the idea that this is necessary in terms of complying with federal law and state law dealing with voting of persons out of the country, primarily military, but other people. The general bond law, this particular section, KSA 10-120, is cited in a number of different statutes, typically where there's a protest petition and election procedure for a tax increase or something to that effect. And it is a shorthand way of basically saying, if you're going to have a special election, you've got to comply in terms of the time frame, the publication requirements, and so on. And instead of repeating the language that you see in Section 1 in these various statutes, you just say an election procedure to comply with KSA 10-120. I think there's, I looked today and I found about 60 different statutes that cited KSA 10-120. There may have been more, actually. Section 2 and Section 3 deal with election commissioners. The office that the four largest counties have is that conduct the elections instead of the county clerk, which is the office that does it in the other 101 counties. The amendment in Section 2 deletes the requirement, the line stricken there in 34 through 36 requires the person be a qualified elector and a resident of the county at least 2 years prior to the appointment. And this would delete that. I believe the testimony will be provide more flexibility in trying to find a replacement. The amendment to Section 3 is another section of law dealing with election commissioners. And currently there's a discrepancy between statutes. The 130,000 population covers the four largest counties. This would strike the 100,000 that's in this particular statute. It's simply a cleanup. Another way to do this, if you were of a mind, would be to name the four largest counties, but that may create some consternation by some by doing that. So anyway, the 130,000 conforms with what's in the statute in Section 2 that's amended. And finally, Section 4 amends the mail ballot election law. This law is the law that's used by local units of government, typically for special elections on tax questions and that type of thing. There can be no partisan election held under the mail ballot election law. There can be basically there can be no election in which a candidate is elected or retained. Typically, you don't. It has to be a question submitted election, and it applies to a number of different local governments. And what the election does here, or the bill does, is provide the same, same time frame for counting these mail ballots as it is for the mail ballot under the election laws themselves. And it would allow the counting of these ballots the last delivery day of the postal service on the third day following the date of the election. So it conforms the mail ballot election law with the other election statutes dealing with mail ballots. If you have questions, I'll come and answer.
Other questions for the reviser? Representative Miller.
I think you just said the magic words, but is this bill simply a conformity bill? Because it was a long explanation.
Yes.
Thank you.
Yes, committee, this is a conformity bill on multiple issues all at once. Are there further questions for the reviser? Representative Dodson.
Yeah, I may have the numbers wrong, but you know, the part you just went over says delivered within 3 days. And I think it's 2319 that we looked at last week. That bill proposed to change the language to 1 day after the date of the election. Do we have to do something in coincidence here in order to keep these together, or do they stand alone?
These are standalone items, Representative.
Okay, thanks.
Committee, are there further questions for the reviser?
Yes.
Representative Topliker.
Thank you, Mr. Chairman. On the issue of, this question is for Reviser Heim. On the issue of the election, I'll find my spot here. The election commissioners appointed by Secretary of State. On that issue, where it is over 130,000 population, what was the thinking in current law as to why that person would have had to have been a resident for at least 2 years prior to the appointment? And has that law been in place for a while, or what was the reason for that? Do you have any idea, Mr. Reviser?
The reason would be to try and get somebody local that has some kind of a connection, I guess. But I think there has been some issue recently finding a candidate to fill a election commissioner spot. And if you look out of state or even out of county, you're under the current law, you can't appoint some person like that. I think Secretary of State's office is more than willing to jump in on this question.
Go ahead and hold that question over for the Secretary of State's office. The chair now recognizes Representative Bishop.
Thank you, Mr. Chair. I have can you hear me all right?
Yes.
Thank you. I have a question that about Douglas County. What is the population of Douglas County? And I remember this coming up when I believe the Secretary of State gave a presentation to the committee earlier, several weeks ago. What is the population of Douglas County, and is that related to our discussion at all?
I believe that might be more focused towards research or Google.
The population of Douglas County, I think, is about 118,000. So, but
all right. So if research could look that up for us and have you don't have to provide it right now, but towards the end of this hearing, we would appreciate that answer. Okay. Are there any other questions for research or revisers? Seeing none, we're going to go ahead and open up the proponents section. Thank you, Reviser Heim. So for the proponents section, we are going to go ahead and call on Clay Barker, Deputy Assistant Secretary of State.
Thank you, Mr. Chair. Can you hear me?
Yes, sir.
All right. The common theme in this bill is inconsistent statutes in our election statutory code. And we've gone through the code. We found about 55 statutes we've identified that we believe need to be fixed. We're only going to have 4 in this particular bill. Otherwise, it would be too overwhelming. And as the revisor said, there are 3 general areas. The first area has to do with the bond election bill 10-120. And as the revisor pointed out, that bill was then cited by many other local election statutes for its timeline. Now, where that bill creates an inconsistency is that it allows these local elections to be done fairly quickly. That makes it inconsistent with Article 12 of the Election Code, which has to do with federal absentee balloting. Now, the federal law requires for federal elections and only federal elections that mail ballots be sent to overseas military 45 days before Election Day. That's a big deal for all the counties. Federal law does not govern our local elections, but Kansas has incorporated the federal 45-day standard and said that should apply to all local elections. So it's inconsistent with the bond election timing. And I'm sure someone will ask this, so I'll answer it right now. We do not know of any military person who did not get in a local election ballot and was unable to vote because of a short timeline. You know, whether it was some private on a forward operating base in Afghanistan, just didn't get it in time. But we want to make sure these 2 statutory sections are consistent with each other and that there is no problem in the future of a military serviceman or woman from Kansas not getting a local election ballot. And the types of elections that are done through this, you know, is again, like the revisor said, it's a whole variety of small elections. So that is just there again to make it consistent. The second area of the bill has to do with the county election officer, and it actually has 2 parts. One is to make the population numbers consistent. One statute said 130,000, one says 100,000. We want to make sure that's clear. It's 130, which we believe is what the legislature's intent was. And I just looked up on the U.S. Census. Douglas County has about 125,000 people estimated, and we should get the census results this September to know its actual amount. So Douglas County is creeping up on that threshold to get an elections commissioner. The other change to the election commissioner statute, while we have it here, was to eliminate the requirement for 2 years residency. Now, the original election commissioner statute, which I believe was passed in 1947, actually required 105 election commissioners, 1 for each county, and it was immediately dropped back down, I think 2 years later, to just larger counties, which makes a lot more sense. But the reason to get rid of the residency requirement is this position has become more and more narrowly focused and technical on the administration of elections, which includes security and management and ballots and multiple statutes. And sometimes the best person may not have been a resident of the county for 2 years. And although I understand the county may want to lean towards someone who already knows the county, it could just be a hometown person who has been away for a year or two, perhaps doing elections in a different county or a different state that now wants to come home. And this statute would allow that, or excuse me, this bill would allow that. The last part of the bill has to do with making the provisions for all mail ballot elections, for the mail part, the same as the mail statute for the mail ballot component for the even year elections that you are all elected in. And there's a difference between them. In the even year elections, we have the extra 3 days for the ballots to arrive as long as they're postmarked on or before Election Day. The all mail ballot elections don't have that grace period of 3 days. And there are I believe it's the Shawnee Mission School District just had a bond election in Johnson County, and quite a number of ballots arrived late and weren't counted that would have been counted with the grace period. Now, I understand there was a question. There's another bill to shorten that grace period to 1 day. And our goal here is to make the 2 sets of statutes consistent with each other. Whatever number of days this committee thinks is appropriate, it should be the same for both types of elections. We're not going to get in an argument about 1 day or 3 day right now. That's not the point of this bill. The point is to make it consistent. The other part We believe this is necessitated by some federal court decisions, so it's a constitutional requirement, is that if a mail ballot in the all-mail ballot election is rejected because of a signature mismatch, the government has to give that voter a chance to say, yes, that was my signature, or I can fill it in. You can't take away someone's right to vote on a discretionary decision that a signature doesn't match without giving the voter a chance to appeal or explain. And what we did in this bill is we tried to take the identical language from the mail ballot portion of the even year elections and move it, just cut and paste into the statutes for the all mail ballot elections. And the all mail ballot elections, as the revisor said, is pretty much any local election that doesn't involve a candidate or a partisan issue. Bond elections, sewer districts, cemetery districts, there's just dozens and dozens of them. And Mr. Chair, that's the essential three parts of this bill. Again, the theme was trying to reconcile differences in statutes that seem to contradict each other, and I'll stand for questions at the appropriate time.
Other questions for the proponent? Chair recognizes Representative Berquist.
Yes, sir, Mr. Barker. How are recall elections handled? Or are they handled at the ballot box, or are they by mail?
A recall election, because a candidate is involved, would be a normal election, polling place with a mail option.
Thank you, sir. Thank you.
Committee, further questions for the proponent? Seeing none. All right, we're going to go ahead and move to the next proponent. Rick Pifo, Chair, Kansas County Clerks and Election Officials Association.
Can you hear me? Can you hear me?
Yes.
Okay. Thank you for letting us testify today. As you stated, my name is Rick Pifo. I'm the Harvey County Clerk and Chairman of Elections and Legislative Committees for the KCCEOA. We support this bill, pretty much all portions of it. And pretty much everybody's already said most of the things I was going to say, other than I've been pushing for this 10-120 to be changed for a long time. It becomes almost impossible to conduct these when basically you have to call the election for the 45th day from the day you say somebody submitted a petition. The day that I certify the petition is okay, I have to call the election on the 45th day from that day and send the ballots out the same day to UOCAVA voters because of the requirement that we send out ballots 45 days. So, and if you don't do that, then you have to pick and choose which law we want to break. And I don't like to break any laws, or none of the clerks like to break any laws. So this would give a 15-day period. And the other thing with doing it on that 45th day, that would have to be on the 45th day, and whatever day of the week that fell on, that would be the election day. This allows a 15-day period to schedule that election, and therefore allows 15 days to get the ballots prepared and sent out to UOCAVA voters, which in our county, we always have some, but it doesn't really matter if you have one or you have 10,000, you'd still have to prepare the ballot and get it sent out. We also support the removing the 2-year residency requirement for election commissioners, just because it's really difficult to find a candidate in the county that has election experience or election administration experience. And especially for these large counties, I mean, you're talking, that's a big job to administer these elections for these large populations and just the sheer numbers that they deal with. We also support making the all mail ballot election deadlines more consistent with regular advance by mail. And with that, I think I'm done. I'll stand for questions when appropriate.
Thank you. Committee, are there any questions for Mr. Pifo? Did I see a hand in the other room? Nope. Okay. All right. Seeing no questions, thank you, Mr. Pifo, for your testimony. Committee, please look at the written proponents. Mr. David Hammett of Loud Light Civic Action Group has written only proponent testimony. And with that, I'm going to go ahead and close the proponent section. And are there any opponents or neutrals that wish to speak to House Bill 2355? I have none listed. Seeing none, both of those sections are now closed. And I'm going to go ahead and close the hearing on House Bill 2355. Committee, with House Bill 2355 that we just heard, I feel like it is a non-controversial bill that we're just basically updating everything to other portions of the statute. Is this something that you folks would be willing to work today?
Yes.
Representative Berquist,
Yes.
would you like to suspend the 24-hour rule?
I would like to suspend the 24-hour rule and work the bill to present to the House.
Okay, do I have a second? Second from Representative Proctor. Discussion on the item. Representative Miller.
I'll support the motion in passing this out of committee if we put it on the consent calendar. Okay, thank you.
All right, so just, yeah, my plan is to try to put this on the consent calendar, just so everybody knows. I will go into further explanation on that once we dispose of this motion. All right, is there further discussion on suspending the 24-hour rule? Representative Bishop.
Mr. Chairman, I need clarification on how I vote. The fact that I'm in my office here in the State House, is that sufficient, or do I need to come to the committee room?
No, you are in the State House. You are permissible to vote from your office.
Thank you, sir.
You're welcome. Real quick, actually, we'll go ahead and dispose of this first before I ask research to if they found that number or not. Okay, so committee, is there further discussion on suspending the rule? Seeing none at this time, all those in favor, please raise your right hand. All those opposed? The ayes have it. All right, so the 24-hour rule has been suspended. Real quick, before we start working the bill itself, research, were you able to find the population for Douglas County?
Sorry about that. Yes, Chairman. So the last official numbers were from the 2010 census, and it was about 110,000. The estimates as of 2019 are about 122,000. We don't have the official census numbers yet, but somewhere around 122,000.
Thank you. Appreciate it. All right, committee. Yes, you can ask a question to research.
Actually, it would be a revisor question. It's related to the population. When we get the 2020 census figures and Douglas County is still below the threshold, if they are, does that lock them in for 10 years until the next census?
Researcher or the revisor?
I'm not sure. That's why I suggested that when I reviewed the bill, that if you are concerned about some county growing into this and getting a election commissioner instead of having the county clerk, the simple thing to do would be to list the counties that have an election commissioner now. If Douglas County has unofficial population of 135,000 5 years from now, do they fit this statute? I would have to do a little bit of research to see how we interpret that. At one point in time, we used to have county estimates that were used in the statutes every year, and they were updated every year.
All right, thank you for that, Supervisor Heim. Okay, committee, just a reminder, this is just bringing everything up to compliance, what we have in current law. So it is just an update bill. So what is the will of the committee for House Bill 2355?
Mr. Chair, I move that we pass the bill out for the consent agenda.
Okay, so you've heard the motion from Representative Berquist. It is seconded by Representative Dodson. Committee, is there discussion? All right, Representative Leon.
Thank you, Mr. Chair. What's a consent calendar?
Yes, thank you, Representative. So the consent calendar means that a bill is of a non-controversial nature, and we have the ability to put it out on the House floor, and after 3 days of general orders, if no one has made a motion or no one's raised an objection to it being on the consent calendar, it automatically goes to final action on the third day, instead of going through general orders and having to come above the line and so on and so forth. So it's a way to expedite non-controversial bills that we push out of committees. We haven't seen much of that this year because basically we've been very hit and miss on the floor, and we have to be on general orders for the day to count. So when we're only doing 1 day a week general orders, that means that the bill would have taken 3 weeks in order to come up for a vote on final action. However, since we're going to be doing a lot of general orders over the next week and a half, it'll allow it to get onto the consent calendar most likely by turnaround next week.
Thank you, Mr. Chair.
You're welcome. Representative Miller.
And in addition to that, any one person can pull it off the consent calendar. If you listen to the chair, we'll get to the consent calendar and he'll read, the clerk will read the bill number and he'll ask, is there objection? And if one person objects, it comes off the calendar. And you can do that any of the three, the very first day it's read, you can do it, or you can wait till the third day and do it.
Correct. Is there discussion on the motion to put it on the consent calendar? Seeing none, Representative, you may close on your motion.
I move my motion.
All those in favor, please signify by raising your hand. All opposed, raise your right hand. The chair believes the ayes have it. The ayes do have it. And House Bill 2355 passes and is going to the consent calendar. All right, body, we are going to take up final action on bills previously heard, which is House Bill 2162. We actually passed this bill out a number of weeks ago. And so here's kind of what happened and the reason why it is back before us again. So as you'll recall, we passed Senate Bill 15. Senate Bill 15 was in regards to the bankers and credit union language. And basically, once we passed that bill, House leadership sent our bill back to us because there are some technical fixes that need to happen within 2162 now because we changed the law. However, at the end of every session, the revisor's office does a reconciliation bill that goes in and updates all those statute numbers and does exactly what they sent the bill back to us for. So with that, we are going to basically just pass this bill out again. We're not going to amend it because we've talked with the revisor's office and we've figured out the best way to do this is just address it in the reconciliation bill at the end of session. And so basically what I would like us to do is pass this out on the consent calendar because it passed unanimously out previously. This is just removing obsolete language that we removed from the Kansas Constitution, and it pointed to the Kansas Constitution as far as the census readjustment numbers. And so it's cleaning up our numbers, as you'll recall. And so that is what House Bill 2162 does. And so I will look for a motion from the committee, and the chair recognizes Representative Berquist.
Mr. Chair, I move that we suspend the rules and move to vote for the 2162 out for passage.
So we do not need to suspend the rules, Representative. We just need to make a motion to send it to the consent calendar.
Mr. Chairman, I move that we vote to pass this out to consent agenda.
Okay.
Second.
Consent calendar, excuse me.
And I think the second, okay, a second came from Representative Neighbor. Discussion committee. Seeing no discussion, Representative, you may close on your motion.
I close.
All those in favor, please raise your right hand. All those opposed, please raise your right hand. The ayes have it. And House Bill 2162 is passed to the consent calendar or consent agenda. All right, body, thank you so much for your work today, and we will go ahead and adjourn the meeting. Thank you.